Welcome to today's edition of Lunch and Law, where we will discuss the topic, SCOTUS has major questions about pen and phone lawmaking, what West Virginia v. EPA means for the future of the administrative state. And here to discuss that topic with us are two experts in this area. First, Jonathan Brightbill, a partner at Winston Strawn, who argued this case in the D.C. Circuit Court of Appeals as a government attorney at the time, if I understand correctly. We won't hold that against you.
Not given what I was arguing.
Well, yeah, that's a very good point. Very good point. And also our colleague here at the New Civil Liberties Alliance, Senior Litigation Counsel, Samp. Welcome to Lunch and Law, both of you.
Thank you.
Thank you.
Well, let's start just for those who may not be as familiar with West Virginia VPA. I'm going to ask you to summarize the case in just a second, Jonathan. But before even getting to that, I thought I would point out that this case has been a little bit unique from the beginning in one sense. I mean, so 2015, the EPA promulgates the Clean Power Rule. There's an effort, even originally, to get a stay against that rule in the D.C. Circuit. The D.C. Circuit says no. It goes up to the U.S. Supreme Court. And for the first time in history, the Supreme Court put a stay on a rule that hadn't even gone into effect yet. And this was the last action of Justice Scalia on the Supreme Court, which I think is interesting, just as a historical note.
It's more than as a historical note, because if the decision isn't issued when it is in the stay and Justice Scalia passes, you have a 4-4 balance on the Supreme Court.
Right, upholding the D.C. Circuit.
Upholding the D.C. Circuit. So the whole course of history is transformed by the passage of 1 week.
That's right. That's right. And this is the kind of rule that once it went into effect, you can't really unring the bell here, right? I mean, you can't unwind all of this sort of regulatory control once companies have already adjusted to it. So this was an unusual case in that the Supreme Court saw that and was willing to stop it, even that early on.
That's right.
But now it's come back to the Supreme Court on the merits. And what did the court decide, Jonathan?
Well, so ultimately the Supreme Court, it was a complicated procedural posture because it was an EPA rule that was issued in 2019 that was repealing an earlier EPA rule, which was the Clean Power Plan rule of 2015. And so you had, and at the same time, there was a separate but related action implementing a new EPA rule for regulating carbon dioxide emissions from coal-fired power plants. So you had a complicated procedural history, but ultimately, the Supreme Court, in the first time ever, that it expressly named and applied this doctrine, applied the major questions doctrine, to decide that the EPA lacked the statutory authority to implement the Clean Power Plan back in 2015, and therefore the EPA had properly repealed the Clean Power Plan in 2019 under the Trump administration, which reversed a holding of the D.C. Circuit, which had said, no, EPA, you have the power. You could have kept the Clean Power Plan. You didn't have to do this. Therefore, we're vacating your repeal.
Okay, well,
complicated.
I'm glad we have an hour to break that down, because we may have already lost some folks. But maybe we'll start with this question that the court handled off the top, which was the standing question, right? So, why does West Virginia have standing to challenge this rule? The government was saying, well, look, we repealed the Biden administration, saying we're not implementing this rule. We're going to work on a new rule. Of course, the new rule that they were going to work on probably wouldn't have looked a ton different from, so the rule that they had repealed, was it the Trump era rule? Is that the one that they weren't implementing?
Yes. So the reason why there was no standing, and it was an easy standing call, I thought the standing arguments were bordered on the frivolous. It was really, the standing arguments were really made to try to lure the justices into kind of
Punting.
Yeah. Being minimalist. And I don't think that the Solicitor General's office, I don't think that any of those people who I know from my time at the Justice Department really believed that there was no standing, that those were good arguments. And the reason, quite simply, was...
But West Virginia was presumably in favor of the previous rule, right?
Well, exactly
the one that
right.
was issued under
and
the
that's
Trump
why
administration.
that's why there was no mootness issue, because West Virginia came in and they very firmly said, we want the Trump rule. We want the new rule that regulates carbon dioxide emissions. We're not saying that it has to go away entirely. The DC Circuit vacated the new rule on the basis of the fact...
if I'm not mistaken, on January 19th
January
of
19th.
2021,
Yes.
right? So the second to last day of the Trump administration.
Yes, and I was on my way out the door, and so didn't get a chance to read it for a couple of days thereafter. But I just rolled my eyes at the timing when
Did you have a chance to print it out before you left?
No, I didn't. I didn't actually. So I just saved a copy of the PDF to my iPad for reading later.
There you go.
So, but West Virginia's position was, we want the Trump rule. That's what we think should be in effect. And the only reason we don't have the Trump rule is because the DC Circuit has said the EPA didn't adequately justify repealing the Clean Power Plan. And so if you vacate the Clean Power Plan direction, or the order bringing that back into effect, where does that leave us? That leaves us with the Trump administration rule. Now, of course, the Biden administration, they can repeal the Trump administration rule now, or the DC Circuit can go on, consider additional arguments against the ACE rule, the Trump administration rule, and they may end up vacating that. But at the end of the day, the narrow decision of the DC Circuit was that the Clean Power Plan was legal, therefore it was irrational for you to move to the ACE rule without explaining why the ACE rule would be better than the Clean Power Plan, since you can have the Clean Power Plan.
And ACE rule stands for what?
The Affordable Clean Energy Rule.
That was the Trump era rule.
The Trump era rule. So the Trump era rule was designed to encourage coal-fired power plants to reduce carbon dioxide emissions by improving their efficiency, the cleanliness by which they burned, the equipment that they used to make sure you got more megawatt hours for less coal burned, those types of things. So that on a kind of per megawatt hour basis, you'd have less carbon dioxide emissions.
This is essentially the heat rate improvements first third of the Clean Power
That's right.
Plan,
Yep.
if I understand correctly. The non-generation shifting portions of the Clean Power Plan are what the new plan. Okay, so the Supreme Court decided that there was a standing in this case. Is that a significant holding for the future? I mean, you suggest,
No.
Jonathan, that this was sort of a frivolous argument. So is there anything there that changes anything for the administrative state going forward?
I don't really think so, other than you could see litigants like NCLA, like us, kind of try to put together a complicated string cite and parenthetical explanation about how
Summer clerks, are you listening?
Yeah, about how in the Clean Power Plan repeal case, the fact that the government wanted to walk away from it or threw their hands up and said we surrender wasn't enough to moot the case.
Right.
I do think that that's a pretty well-established principle of law anyway, but this could certainly be another arrow in that quiver.
Okay. Rich, same question to you. Do you think there's anything here for just in the sort of justiciability part of the opinion that is
I don't think
that you'll
so.
be citing in the future?
I think that it's significant that Justice Kagan's dissent did not really challenge this, and there really is a major difference, I think, between mootness and standing. And so that the government tried to make this a standing case, but rather it was clear that at least at the beginning that there would have been standing. And so if the later actions of the administration somehow mooted the case, that's a much tougher standard for them to meet, and they really have to show that there's no possibility that it could recur, and they did not show that here.
I'm not sure I can find it in short order, but I think Chief Justice Roberts, who I didn't mention, delivered the opinion here. This is Chief Justice Roberts joined by Thomas, Gorsuch, Alito, Kavanaugh, and Barrett. And then Kagan filed the dissent, joined by Breyer and Sotomayor. But Chief Justice Roberts sort of gleefully, I thought, cited the government opinion, or excuse me, the government brief at one point where they referred to mootness, and he said, "Aha, that's a telling admission. This is they're arguing mootness when they're trying to argue standing." But
They didn't believe in it.
yeah,
They didn't believe in it.
so all right. Well, then moving on from the justiciability portion of the decision, Rich. Is this the first time that the court has mentioned the major questions doctrine?
They've certainly had plenty of cases before this in which they have kind of raised the same concept, but this is the first time, I think, that the court officially used the term major questions doctrine and endorsed it. And in fact, I think this was a lot closer case for application of that doctrine than some of the earlier cases. Perhaps the best prior example was when FDA decided that it was going to start regulating cigarettes as a drug, even though it was pretty clear from the entire Food and Drug and Cosmetic Act that Congress had never really thought of cigarettes as a drug in the sense that they were asking to be regulated.
And cigarettes were not a drug delivery vehicle.
Yeah, I mean, I think that was a pretty obvious decision. Here, it is a lot closer in that about 15 years ago, the Supreme Court did decide in the Massachusetts case that carbon dioxide is can be labeled a pollutant and can be controlled by EPA under the Clean Air Act, and so in a sense, EPA is acting within its normal playpen. It is regulating the air. But on the other hand, it was also very clear that this would be a significant expansion of a statute that had not been applied before. And so the court said this would have such a major impact on society that we're going to label this the major questions doctrine. And we are going to say that in the future, courts in cases like this ought to be pretty hesitant before they interpret a statute as having been a congressional authorization of that kind of regulation.
One of the other cases that the court cites is the UARG case, and I believe you were involved in that one as well, Rich, back in, 2014, something like
I can't remember the year. It was the
Yeah.
year when at my former employer, the Washington Legal Foundation, we filed an amicus brief in that particular case, and basically that was another Clean Air Act case, and it was an example of the government going perhaps well beyond what it had done in the past, but again, it wasn't, I think, as clear an example of the agency acting within its normal bailiwick, but nonetheless calling for a major expansion. So this is really the first case where they have flat out said a major question should raise a red flag.
It's also the first case where not only do they label the doctrine, and it has not.
Announce it with fanfare almost.
Right.
I mean, Kagan kind of accuses them of.
She does, and
this.
which is not true, right? This is not sprouted like Athena from the head of Zeus, right? I mean, it has been a long time in coming, and there were a lot of precedents along the way. But
Although more recently. But go ahead. I'll ask about that in just a second.
Well, yes, okay. But one question that was really unanswered until this, and this is one of the reasons why not only did they announce it, but we actually really kind of understand this doctrine for the first time, since it now has actually been applied, is that there was debate in the academic community and among the litigants who were invoking this doctrine as to, we can see that there is a major questions doctrine. It's been, thanks to Cass Sunstein, it's been labeled the major questions doctrine, circa 2006. And
Post Brown and Williamson v. FDA.
correct, yes.
the case that Rich was talking about.
Right, and the FCC case also coming out of the Clinton administration. So we know that there's this thing, right? But it was unclear how it worked, and would it work as a everyone knows the two steps of Chevron. One, step one, the statute on its face. Step two,
is there an ambiguity? Yeah.
And the big open question was, is this a Chevron 1.5, which is that we don't move on to Chevron after construing the statute, right? We give the statute its best interpretation, and if we think that there's some give in the joints, we're nevertheless not going to defer to the agency. Is this a Chevron 1.5, or is this a Chevron step 0, something that the court does before it even really looks very closely at the statute?
So if it were 1.5, then you would say, is there an ambiguity in the statute? Yes. Is this a major question? And then there's sort of a fork in the road. If it is, maybe you don't go to step 2.
Or you make your step 2 harder, or you look more closely at what the agency's proposing to do with that delegation.
But that didn't happen. Chevron isn't even mentioned in the decision.
That's right. That did not happen here. What happened here is it's now pretty clear. It is clear under this holding. It's step 0. Before you even spend much time, before you even look at the statute, you look at what the factors. You figure out, is this a major departure, so to speak, or is this a question of major economic and political significance? And if so, and along as part of those factors, a departure from what the agency has done in the past. And if so, then now that I've pulled out the statute, where's the clear statement that says you can do this? And it wasn't there for the EPA to create a clean power plan for the United States
which was the only question in this case, according to Chief Justice Roberts.
Right. Right.
Rich, you had a whole panel about this last month that I would direct people toward if they're interested in sort of the Chevron or the absence of Chevron, in this opinion. But maybe you could sort of summarize some of the discussion from last month. And is it significant that Chevron wasn't mentioned at all in this decision? After all, the D.C. Circuit opinion turned completely on Chevron, as I recall. Jonathan Blanche, so that maybe you don't agree with that.
Well, in the sense that it turned entirely on Chevron in the sense that the D.C. Circuit rejected the Trump administration argument for the repeal that Chevron was unavailable.
Okay.
Right, and so by determining Chevron is available, you're correct, but it was not a application of Chevron per se.
Okay.
Going back to what I've said about Chevron in past sessions, I think it's disappointing that the Supreme Court doesn't mention Chevron. I think that you're absolutely correct that this decision makes it very clear that this is a carve-out from Chevron. Chevron does not apply in cases involving major questions. But the court didn't explicitly say that. It should be obvious to people, but without saying that, the real problem has been that the Supreme Court has, over the years, refused to apply Chevron. It hadn't done so in about 7 years, suggesting that Chevron has been cut back upon. But lower courts have a tendency to think that Chevron is the easy way out of every statutory interpretation question, and they provide deference to the agency's interpretation of a statute. And unless the Supreme Court explicitly says, here are cases where we determine at what's known as Chevron step 0 that Chevron has no applicability whatsoever, unless you say that, district courts are going to continue to apply Chevron in instances where perhaps they should not.
Or you have a democratically appointed judge who's reviewing a Trump administration rule. We actually did an analysis at one point, and it was in the context of preparing for the argument for the Clean Power Plan repeal. And not surprisingly, all kinds of judges discovered Chevron step 1 during the 3 years
compared to their previous Chevron
correct.
sort of
Correct. If
tendencies.
We kind of looked at, we segmented on, Obama era rules and Trump era rules.
Has that been turned into an article? Is that publicly available?
No, but somebody can jump on this because the data, the information is true,
Okay.
right? We did the analysis, and
If you haven't picked your note topic yet,
we did the analysis, but in particular, the two judges who sat on the D.C. Circuit panel that I argued in front of, I think it was something like between the two of them, they had decided one case on Chevron Step 1 grounds against the agency prior to the Trump administration, and then there were at least a half dozen, maybe more, during the Trump administration up until the Clean Power Plan repeal.
that's a pretty significant discrepancy,
Yeah,
I would say.
yeah.
Okay, so how major does the question have to be in order to be a major question? Is this going to be like, so the non-delegation doctrine, I think Cass Sunstein famously said it had one good year and like 80 bad years since then or something like that. Is this going to be like that? So this is a major question. The court doesn't really, I guess it talks about some of the factors that went into determining that this was a major question, but it doesn't draw a line. It certainly doesn't say that anything less major than this won't be major, and it doesn't say it has to be more major than, I guess that's another way of saying the same thing. It doesn't have to be this major or more for this to apply. So where's the line going to be drawn?
Well,
Oh, sure, turn to Rich on that.
Oh, I'm happy to go first.
I think it's going to be a difficult line.
Deferential.
A lot of judges are going to say we know a major question when we see it. I don't think this is going to be like the non-delegation doctrine where it doesn't get applied for many decades. It is going to be applied, but I think it's going to take a long while for courts to figure out exactly what a major question is. And in some senses, I think that's good, because I think that the real issue ought to be not so much, is it a major question? The real issue ought to be, we ought to examine what was congressional intent, and looking primarily at the language of the statute, did Congress intend to give this power to the agency? And certainly the fact that it is a major question, and Congress nonetheless didn't say anything explicitly or implicitly that delegated the power in this particular situation. That should be one pretty strong factor to consider in saying that that the power was not conveyed. But at the end of the day, hopefully we are all people now who are looking at statutory construction as an exercise of looking at the actual statutory language. I mean, that was what Justice Kagan said in dissent.
We're all textualists
We're
now.
all textualists now, and except maybe not the majority. And I'm glad that she's on board fully, and I think everybody ought to be on board of textualism. And if we use the major questions doctrine as simply one more tool in textualism, I think the problem of what is a major question will become perhaps less important.
Same question to you, Jonathan.
Yeah, I don't know, if you look at the cases, that the questions will have to be that major. I mean, certainly the language talks about major economic and political consequence, right? But one of the cases in the line of cases of the major questions doctrine is Oregon v. Gonzalez, which is...
Does DOJ have the power to yank the DEA licenses from doctors to write prescriptions if they violate federal law in terms of physician-assisted suicide drugs, right?
Assisted suicide, right? I mean, in the grand scheme of things, that's not really that major, right, compared to some of these other things in terms of the agency's actions.
Maybe not in dollars and cents terms.
No, not in dollars and cents terms.
Life and death terms.
But I think that's important, right? Which is I think it's going to be very difficult to say that major necessarily requires the kind of economic consequences that the Clean Power Plan unquestionably did, or taking over tobacco for the first time in 7 decades, would have represented, that kind of thing. So I don't think that it has to be, for lack of a better term, that major. But to me, I think that the doctrine, which I have obviously played a role in having named this because we argued it with this name, right? But I'm not actually convinced that it's the best name for the doctrine, particularly as it's evolved, because I think when you look at the cases and you look at what the doctrine is really about and even the factors, it's more about the agency's departure and sudden pronouncement to be able to do things that nobody thought it had the ability to do. And that's really the kind of key theme that runs through all of these major questions cases, is that the agency suddenly woke up one day and said, you know what, I know about Chevron, and we've now been living with Chevron for 15 years, and I can reverse engineer Chevron to make arguments that this is ambiguous and then be able to claim this new power and do this new thing that nobody in their right mind thought that we had the capacity to do, right?
And that's the exact same problem. So you're coming at this question from the perspective of a former government attorney. We had Roman here for your panel last month,
Okay.
and he had the same observation from his time in the Solicitor General's office
Yeah.
of agencies were doing that, right? They're consistently trying to see, well, what can we get away with
Yes.
under Chevron, rather than what does the statute actually mean? What
Correct.
did Congress mean?
But I think all of that, I think, underscores the fact that it's really not the major question doctrine that's determinative. It's not that the question is major, it's the red flag that is raised when an agency all of a sudden is asserting power that is 180 degrees different than what it has asserted before. That's a pretty good indication that perhaps Congress didn't intend to convey that power. And you mentioned the Gonzalez case. I mean, there was a case where this was the federal government overruling what the states had done. So that raises a federalism concern that was kind of somewhat unique in that case. And all of these factors go into what did Congress intend.
So is this just Gregory v. Ashcroft on steroids? It's just that's the case that creates a clear statement rule when federalism interests are implicated. Is this just another?
Well, that's another reason that you would doubt that Congress intended to do what the agency said they were doing.
Yeah, we cited that case as well to support the repeal, right? That was another clear statement rule canon because we were dealing with the Clean Air Act, which delegates to the states 111D in particular. So we also invoked that. But you said something which I do a little bit disagree with, which is that major questions doctrine is about textualism. I don't know that it is. I kind of think it isn't. It's because it seems to me that what really happened here is that the Supreme Court, created the Chevron doctrine many years ago, and
Six justices created
six
it.
justices created it
Three
many years
justices
ago.
weren't sitting at all when Chevron was decided.
And certain conservative textualist judges supported Chevron and at least the principles behind it for many, many years, right?
Scalia notably. But we had this development, and it's unquestionably true that the government does this. The agency started to do this. Is they began to reverse engineer based on Chevron, assuming that they would get Chevron, and then banking on lower court judges to be lazy, unsophisticated, not as stringent, not having the guts to say no, whatever it was. And that ball began to roll. That stone began to roll, and the snowball got bigger and bigger. And I do think this is not necessarily textualist in the sense that the Supreme Court has, and these justices have looked back at what's happened, and they've now, created and formalized this idea that as a balance to Chevron, we've got to be looking more closely up front before agencies are allowed to go off and go running. And I think these factors are not textualist factors. I mean, some of them are, at some sense, right? But if the fundamental analysis is the agency suddenly doing something that looks a whole lot different from what they used to be doing, right? If that's the core of what the court is looking at, and I think that is, the core thread that runs through all of these, that's not a textual analysis. That's like federalism,
right? That, federalism is, we got states and we got the federal government, and we need to have a rule in place that under our constitutional system that respects that. This is agencies, Congress, agencies are out and running. We need to have a rule that under our constitutional system that accentuates the separation of powers and protects Congress and makes Congress speak more clearly.
And I think we're in agreement on that point. I think that the ultimate anti-textualist doctrine is Chevron itself. And so if you are a textualist, you have severe doubts about the validity of Chevron. And so by invoking the major questions doctrine and other such doctrines that perhaps themselves are not totally textualist, what you're really doing is cutting back on the ultimate anti-textualist doctrine and saying we're going to look just that much more closely at what Congress really intended. And if you're looking for presumptions out there, perhaps Chevron is among the weakest of the doctrines.
So it may not be a textualist doctrine, but it may be a pretextualist doctrine. And I don't mean in the sense of it being a pretext. I mean in the sense of you have to do this before you can get to textualism.
Yeah.
Jonathan, you mentioned that that's part of the holding here, or part of the rationale for the holding here, is that what the EPA wanted to do was outside the agency's traditional expertise.
Yeah.
And I think that that's really beyond dispute here. If you're talking about electric generating capacity and transmission, EPA, that's not even EPA, that's not the right agency. There are other agencies that deal with that. FERC, for example, might have regulatory power there. But some of the other rationales that were mentioned were, and I thought it was funny that Chief Justice Roberts cited Justice Frankfurter for this point, since he's such an Frankfurter is such a pro-administrative state guy, but he talks about newly found powers after a statute's been in use for a long time, suggesting that maybe the power isn't there. Related to that, sort of invoking a statute in ways that are inconsistent with prior applications of the statute. Roberts mentions that Congress had failed to vote on this exact concept before.
Yes.
And then, of course, the fact that this is a major policy question. So that leads me to ask, are there some mini holdings here, M-I-N-I, I'd say some sort of holdings within the case? Do you have to have all of these things going against you in order for the major questions doctrine to go into effect? You have to have all these things going in the same direction to invoke West Virginia v. EPA in the future?
I would say no, if you take the Supreme Court at its word, which I do, which is this is not a new doctrine that we are creating. This is our recognition of principles that have run through many of our cases before this. And if you go back and you look at those cases, you're not going to find all of those factors necessarily in each of those prior cases.
But boy, if you twist these threads together, you got a pretty strong rope.
Right. Right.
Yeah. So we mentioned before that there were other cases. I alluded to the fact that there had been a number of recent cases where the major questions doctrine had been invoked at least silently, if not allowed. And so two of those were cases that involved issues near and dear to the heart of NCLA.
Yes.
So the Alabama Realtors case was the one where the Supreme Court finally decided, after a hiccup, that the CDC does not have the power to issue a nationwide eviction moratorium under its statute. And then under the OSHA vaccine case, the Supreme Court decided that OSHA did not have the power to mandate that folks who are subject to OSHA in the workplace get vaccines. So is this doctrine really just a question of, does the agency have statutory power to do X or not? Is that all this boils down to? And I've got a follow-up, but I guess I'll recognize myself for that at the appropriate time.
No, I don't think so, because this is I think the way it's been established, this is a pre-textual analysis that looks to then whether we're going to apply a clear statement canon to the text. And so, obviously part of what's happened here, and part of why I think that the major questions doctrine may continue to get some play here, is that we've seen some really very aggressive administrative actions.
Jaw-dropping, I think.
Jaw-dropping.
I've used that word.
Jaw-dropping. And,
Before.
and they become more common, right, and particularly. And there's several in the pipeline, which I have no expectation that the agencies involved are going to look at the Supreme Court's EPA rule and say, well, we're going to dial this back and we're not going to go there. In fact, for some of them, the heads of those agencies are already on record saying that doesn't mean anything to us. We're different. So, and I don't think they're different, or I think it's unlikely, and they're going to be held to be different if it gets that far. And then there's some that are on the margins. So I think we're going to see some play on this doctrine in the coming couple of years, because I don't think that several of these agencies are going to back down.
So the court will have an opportunity to refine the major questions doctrine, perhaps?
I think so.
I think one of the things that...
If the DC Circuit, unless the DC Circuit gets the memo,
Right.
or some of these things get routed through the Fifth Circuit, and
Which they might,
and
if I were a betting man.
and I think that circuit's more likely to get the memo, and so maybe they don't make it up to the Supreme Court right away or as quickly, or at least on these that are immediately in the pipeline.
Although some of these things have to go through the DC Circuit.
Some of them do.
Yeah. So I think when the decision first came out, first started reading it, first started hearing articles or seeing kind of hot takes on the decision, I wasn't immediately thrilled with the decision. Rich and I have talked about this a little bit, because the idea that there's a major questions doctrine suggests that if the question isn't major, then it's okay for an agency to do something that it doesn't have statutory authority to do. And maybe this just gets into what you guys were talking about before, that, oh, well, that's kind of a misnomer, that maybe we just haven't given the doctrine an appropriate name. But I do wonder whether there's something in here maybe for the administrative statists out there to latch on to say, well, look at that clearly under this version, whether you think of this as being a cousin of the non-delegation doctrine or what have you, under this version, agencies can get away with a lot. They just can't get away with it if it goes all the way to a major question. Should I be worried about that?
I think that's at least a concern. I mean, if you read Justice Kagan's dissent, she seemed to say, look, it's well-established doctrine that agencies, when they have been given the authority to broadly write rules and regulations implementing the statute, that we presume that when Congress did that it intended to give the power to the agency to exercise that jurisdiction. And so some courts might say, okay, now that we've read West Virginia v. EPA, we realize that there might be 2 or 3 or maybe 4 cases out there where we have to concern ourselves, but we can still go whole hog in giving deference to agency interpretations in every other case that is out there, when in fact, of course, what they really ought to be doing is looking at the entire statute. And as Justice Kavanaugh and others have repeatedly emphasized, even Justice Kagan, in one of her decisions recently, has emphasized you don't ever get to Chevron or our deference unless you have really, really closely studied the statute and decided that it is genuinely ambiguous and you have no other way of interpreting the statute, and only then would you get to Chevron step 2.
Yeah, and your concern, I have that concern. It's a glass is half empty view of the penumbra of this decision. I want to think that there's a glass half full view of the penumbra of this decision.
Well, let me put a finer point on it for you. This is the final paragraph of the decision from Chief Justice Roberts. A decision of such magnitude and consequence rests with Congress itself or an agency acting pursuant to a clear delegation from that representative body. I'm sorry, so now, as long as Congress is clear about a delegation, the agency can do whatever it wants, even if it's, for example, using legislative power when agencies aren't supposed to use legislative power.
That's a negative implication of that, right? I mean, some would say he's just summarizing the rule in another way. But look, I mean, one thing I think he gets at, and this is my ultimate hobby horse now going forward that I think that people need to talk about, is that it's not Chevron. I mean, it is Chevron, but it's not Chevron. The problem, Chevron is a symptom of Congress delegating it all. And what folks who want to protect the power of the people and protect the power of states and protect and rein in the administrative state need to be talking about is not so much how do we finally get the right case to cabin Chevron, although that'll help when that happens. But Congress needs to just stop delegating, okay? Until the Clean Air Act of 1990, Congress would write the numbers. It set the standards. It determined the pollutants. It set the standards. It had experts that were members of its staff. It held hearings. It legislated. And in the Clean Air Act of 1990, and then in many of the statutes in the environmental space that have come after, right, you now have what Congress, that was too much work. We don't want to do that anymore. So what are we going to do? We're going to write a final set of standards that are going to be in effect until 1996 or 2003 or whatever. And then EPA, every 8 years, you should do a review to determine if you're going to ratchet down the standard, and then if you're going to ratchet down the standard, you ratchet down the standard, right? And
talk about your one-way ratchets.
And the problem in the environmental statutes across all the administrative state statutes, I think, is that Congress needs to stop delegating, and it needs to return to itself the idea that statutes will lapse or statutes will cap, and we need to go back and we need to be the ones that do the work. And part of people who are on the libertarian or conservative side of the aisle and are concerned about the growth of the administrative state need to do is start to get to these senators and congressmen and what have you, and their staff, and get that message out too, which is obviously we need the courts to be more stringent protectors of the rights of Americans, but we also need Congress when it has the opportunity to stop delegating.
I've noticed from my time on the Hill and since that people who are elected to office aren't big on democratic accountability. I don't know if others have noticed this as well. So taking what you say, Jonathan, does that mean, so there was a lot of enthusiasm here at NCLA and other quarters for potential revival of the non-delegation doctrine. Does West Virginia v. EPA, does that mean that discussion is moot? Will there still be, should we still be looking for the court to take a non-delegation case and maybe revive that doctrine, or is this a sort of fork in the road? They've decided to go down this major questions path instead.
I see no relationship between this decision and the non-delegation doctrine. Nothing that Justice Roberts said suggested that he was reluctant to address that issue. Both the concurring opinion of Justice Gorsuch and the dissenting opinion did talk about it a little bit, but there's nothing in his opinion about it. That quotation you mentioned from the end of the decision I found totally untroubling, because what he said there was, if Congress clearly delegates something, it gives a clear delegation, that is fine. You can delegate the authority to carry out powers. Had the Clean Power Plan been written by Congress, I might not have liked that plan, but it would have been clear and it would have been within Congress's powers under the interstate commerce power.
Certainly would have had more specificity than a lot of statutes.
Yeah, and there's nothing in the decision that suggests that it's okay for Congress to delegate any legislative power that it wants. And instead, I think there has been a lot of talk from the court in recent times that no, Congress really does have to do exactly as Jonathan is saying, and has to have some sort of, at the very minimum, intelligible principle that is lacking in so much legislation adopted in recent years.
Yeah, I don't think that this is a fork in the road vis-a-vis the non-delegation doctrine. And I think in some respects it's founded on the non-delegation doctrine to some extent. That's the reason why, lurking in Justice Gorsuch's opinion, not expressing Chief Justice Roberts' opinion, part of what's animating the formal recognition of this clear statement rule is that we're not going to presume that Congress is delegating this much authority when it's writing its statute. And who knows? I mean, ultimately, I don't read that last sentence to say that there's no point at which Congress can stop delegating necessarily. You know, just because he didn't add that additional caveat in his decision, he's getting signed up for 6 justices, doesn't necessarily mean that he himself has written it off entirely.
Okay. The title of today's talk refers to pen and phone lawmaking. That phrase actually comes from the Gorsuch concurrence, not from Chief Justice Roberts' majority opinion. So is the court, is this a shot, if I can mix metaphors, is this a shot across the bow of either the Biden administration or the administrative state, however you want to think about it, against pen and phone lawmaking, against executive orders and these sort of ways of ruling extra legislatively, if I can put it that way, or is the fact that I think it's Gorsuch and Alito that signed on to that, and just those two, pen and phone lawmaking isn't the Roberts majority wasn't really having anything to say about pen and phone lawmaking, because after all, I mean, this wasn't really, the Clean Power Plan isn't really pen and phone lawmaking.
Oh, sure it was. It's the paradigm, right? It's the first one, right? I think it's Obama, right? I think this is the rule, right? The idea that they wouldn't do a climate legislation. I think this is actually the rule that President Obama
Was referring to?
Well, that was the issue.
Ultimately.
The issue that President Obama invoked that phrase with, and then led to this rule. I could be wrong about that, but someone else can check that for their note too. That's where I actually think it's this rule is where that phrase comes from, and I definitely think this was a shot across the bow, and I say that based on the following pieces of data, not just what's in the decision. I actually think the decision is very measured by Chief Justice Roberts, although he's got various.
Subtle digs.
Subtle digs. He's got some subtle digs, but in the wake of the Supreme Court issuing the vaccine mandate decision, and in the wake of them issuing the moratorium decision, where this doctrine is cited but not expressly adopted,
Which are definitely pen and phone lawmaking.
definitely pen and phone. The oral argument in this case happened, right? And listening to the oral argument in this case, right? This decision, you could hear that this was the decision. This was that this was where Chief Justice Roberts was, by the questions that he was asking, by where the focus of the argument was. You can't always tell. You can't listen to every Supreme Court argument and necessarily know what's going to happen. But certainly you can listen to Supreme Court arguments and you think you have a pretty clear picture, right? This is one of those instances where you listen to that argument, you go back and listen to the transcript. If you hadn't listened in the first place, you hear that this is going to be the decision by the argument that is conducted. And as that argument is being conducted, Chief Justice Roberts is not anywhere near as measured in his questions from the bench as the opinion that was generated. And so is this a shot? I think it is, because I think if you look at the data that came before that argument, you listen to that argument, you look at what's happened since, I think that this was a shot across the bow. And I think that there could be, across those 6 justices, a lot less interest in allowing this kind of stuff to continue.
So when there's a shot across the bow, I think the metaphor would imply that the ship of administrative state should turn in response to that. Will the ship of the administrative state turn in response to this shot across the bow?
We hope it turns and it hits the iceberg, which causes the seals to buckle and 5 of the 8 chambers to fill. Because if it were only 4, then the Titanic wouldn't have sunk.
But you're okay with the bureaucrats getting off in the lifeboats then?
Yeah.
Fair enough.
I have seen nothing, however, to indicate that the Biden administration is looking upon this decision as anything other than a decision from a rogue court, and the answer ought to be to change the Supreme Court rather than to buckle in any way. So this fight is far from over.
They're not taking the hint.
No.
One thing that I probably should have asked earlier, but I meant to ask you about, Jonathan. 111D it's a tiny part of the statute. I think I saw in the opinion, was it Senator Dernberger from Minnesota? Do I remember that correctly?
This was the sixth time 111D had ever been invoked.
Okay. But he said that it was hardly ever used. I think it was something
Correct.
like that was the quote.
And it was in the Clean Air Act of 1970. And this was the 6th time it was used, and 4 out of the 6 were within the first 3 or 4 years of the act. And there was one effort during the Bush administration, and
having to do with acid mist from
interstate transport, and they talk about that in the decision.
Okay.
And then that one, and then there was the Clean Power Plan.
I think it's telling that this particular section of the Clean Air Act is called the New Source Performance Standards. The emphasis on the word new. In other words, this was a section of the act that was primarily focused on adopting emission regulation for new sources like new power plants.
Newly built plants,
and
right.
yet this particular Obama administration plan was focused almost entirely on old power plants and trying to get rid of coal-fired power plants.
Well, far be it from NCLA to make too big an issue of using the word new for something that's been around for a while, but I did notice the same thing. And the other thing that jumped out at me from the Roberts opinion is he pointed out nothing seemed to hang on this, but maybe that'll be my question, should something hang on this? He pointed out that under the Clean Power Plan, the emission standards that the administration was trying to issue for existing sources was actually a stricter standard that was in place for new sources, which just seems irrational to me.
Yes. And why was it, right? It's because the Clean Power Plan, and I think that people in the abstract kind of understand that there was this thing called generation shifting, that part of this would rely on the idea that EPA was going to encourage movement to renewables, right? But
and let me just clarify that for people who haven't been following that. So there were sort of 2 aspects of that, right? One was to disincentivize coal-fired plants and shift some of that to natural gas-fired plants because the emissions are lower from gas-fired than from coal plants. And then there was a sort of a second part of it that was aimed at really preferring more wind and solar versus any other kind, pretty much. Strangely, nuclear power gets left out of the equation, even though there are no emissions from that. I don't understand that, but
wasn't politically popular, right? I mean,
it's not, I guess.
But the fundamental departure here was this: is that every rule under 111D and the Clean Air Act generally, right? The EPA looked at whatever it was that it was emitting, and it said, how are we going to reduce the emissions from that? What technology? What techniques? What processes, and then we're going to require that to make the air cleaner. And that would have economic consequences. But ultimately, EPA was a technical regulator that was reducing the pollution that was coming out of sources. And what the Clean Power Plan did, and it did this, it literally did this, right? I mean, if you imagine like a map, a World War II movie with the giant map of Europe, okay, spread out. I mean, what EPA functionally did was take out a map of the United States, figure out where all the power was coming from, where all the coal plants were, all the gas plants were, where the renewables were. And then they went 6 years into the future. This is EPA. This is the environmental regulator. They went 6 years into the future and moved the pieces around on the map of America where they wanted coal plants to go out of business and wanted wind to come on and more. And then after they figured out what their plan for America was, they backed into numbers.
The emissions limits.
The emissions limits that they thought would drive America to look like their clean power plan.
Right. So in other words, how many of these can we take out of commission without wrecking the electricity grid?
Correct.
That's the number we want to take out. Now, what do we have to set the emission limit at to get those plants to all go bankrupt?
Yes.
And shut down? That's the limit.
And the best part,
Which isn't really what the Clean
Air
Act
Act
is about. It's about what's the safe level for breathing and that kind of thing.
right? And the greatest part from the Clean Power Plan, at least from the proponents of it, is not only do we get to bankrupt these entities, but we're going to make them pay and subsidize the entities that we want to bring on along the way. So, and I think that lurks in Chief Justice Roberts' decision, right? That he understood that kind of fundamental aspect of it. And one of the reasons why this was an issue of major economic and political consequence, because not only is energy a big deal, does energy underlay everything, but you know what? Congress pretty jealously decides where the money moves and who gets subsidies and who doesn't get subsidies, right? And the idea that, as part of their grant of power, EPA is now going to be in the subsidy business of deciding where all the money moves around the country and who's, I think is a pretty remarkable departure too from where they were.
I have one question on that, but I just want to let people know I'm going to come to the audience for questions here after this next question. So be thinking of what your questions are, and I think we have a microphone that will be coming around. What you just said, Jonathan, makes me think of a different Chief Justice Roberts' opinion, at least I think it was him, in the Department of Commerce case, where he was pointing out that the reasons that the Department of Commerce was saying, or at least his take on it was, the reasons they were giving for wanting the census case, the reasons for wanting to ask this question in the census, the reasons that they said they wanted to weren't the real reasons that they were doing it. And I wonder if there's a bit of that sort of pretext flavor here as well. EPA said they were setting emissions limits for emissions reasons, but they weren't really. They were really setting emissions limits for electricity redistribution reasons. And I think Chief Justice Roberts doesn't like it when agencies say they're doing one thing and pretend to do another.
Yeah, I would agree with that.
You have any thoughts on any of that, Rich? Or are you ready? Should we go to questions?
I'm ready for questions. The one thing I would like to point out is that Justice Roberts also wrote a very strong dissent in the City of Arlington case, and he made it very clear in that decision that he doesn't like the idea of agencies being able to set their own jurisdiction. So I think that is probably a good indication that is the area that the major questions doctrine is most going to focus on.
And he did not pull any punches in that dissent, unlike the majority opinion here. So I'm gonna go back on what I said. I have one more question for you. So do you think that this decision cuts back on City of Arlington at all?
Oh, very definitely, yes.
Yeah, that's what I was thinking too. Okay. Have a question, maybe? Peggy Little?
Hi. Can you hear me? Good. I enjoyed your explication of what was going on. This is just a comment that when you described the map of the energy sector, I would only add as a comment that central planning has always worked out really well. and I don't think that's actually how we organize ourselves. But my actual
Tell that to the EPA.
Yeah, my actual question is, would something like off-road driving be a better term for major questions in some of the ways that you've been talking about here? And I'm going to throw out an example. Would it be okay if Congress, in the frenzy after the pandemic hit, if Congress said to the CDC, okay, you figure out whether there needs to be an eviction moratorium. Does that work?
Well, that would raise questions under the non-delegation doctrine. If they very explicitly delegated that authority, it wouldn't be a statutory interpretation question. Very clearly, they did delegate it. And then the question is, did they delegate it with enough intelligible principles? Did they actually establish the policy that should be used in deciding whether CDC should go ahead with the moratorium? I mean, if they did that and all CDC was asked to do was to answer the factual questions that were set forward by Congress, I don't see that as a problem. But if you just say, in the public interest, do you think it's warranted, that would be insufficient, and that would be a non-delegation violation.
And it might not, I think what you said is a correct statement of current law, but hopefully where the Supreme Court is going is that under a non-delegation theory, that they might look at something like that and come to a different conclusion.
What I'm thinking about
might
is
say all legislative power comes from Congress, so no, you can't delegate that legislative power.
right. Well, what I'm thinking about is should they look at the organic statute and say CDC wasn't even set up to do this, number one, and number two, the obvious federalism concerns here in terms of state courts being the where power to evict or not evict or to decide those questions has been generated. So I just throw that out as an interesting hypothetical.
And I'll add onto this, will there be a major question step towards a non-delegation doctrine that looks not just at whether there's an intelligible principle, but that you can have too major a question to delegate, right? Is essentially what this discussion is driving at, right? And I will add to that there's one constitutional property right that's in the original Constitution, right? And which is the Takings Clause, and that one could construct a theory around the idea, along with the other areas of constitutional rights and the power limits on the power of Congress, though, that if you're going to delegate something of a major economic and property consequence, right, that's something that Congress has to do itself. If they're going to move the money around and they're going to move transfers between large groups of people, then that's something that they should be doing themselves, not delegating to agencies, which something like the eviction moratorium clearly did and does.
I think there was something in the opinion too, I'll have to go back and look, about the organic statute and sort of cautioning agencies not to try to read too much into organic statutes. It was kind of an aside, but Jonathan, what you said about having a sort of major questions within the non-delegation doctrine is something that Rich and I have proposed in an article that we wrote. So I hope you're right about that. Next question.
Hi, I'm Robert Miller. I'm nobody. So I view.
Can we hear the question before we decide that?
Well, I view I'm not an expert. I view the non-delegation doctrine as prohibition against power flowing from Congress to the agencies, and the major question doctrine as agencies arrogating power that hasn't been explicitly given to them. And I see the major question doctrine as the most extreme example of a normative question: should agencies be acting in place of Congress? And a common thread I see in West Virginia, in Alabama Realtors, and in Richard's bump stock case is that Congress considered legislation and failed to do so. They chose not to do so. They let it expire. They hadn't gotten there yet. And then the agency stepped in and did it.
The tobacco case too.
The tobacco case, exactly. Yeah. So could situations where Congress could have legislated and did not be a special factor counseling hesitation for agency action?
I think that's a good question. I especially like the idea that one of these governs directionality one way, the other governs directionality the other way. It's interesting.
I think that Chief Justice Roberts' opinion does go into that question and takes all that into account. But I do think there is something to be said that when you're interpreting a statute, what you're interpreting is what the Congress that passed the law, whether it was 1980 or 1934 or whatever, it's what they intended. And it is a little difficult to try to figure out what the 1934 Congress intended based on what the 2020 Congress failed to do. So there has to be, I think, limitations on that.
I would agree there has to be limitations, but since the West Virginia decision, there's been a lot of talk of, oh, so Congress should, game the system now, or consider all kinds of things and vote them down so that they can cut against the major questions doctrine. And I think ultimately what that comes down to is this issue of, again, Congress's intent. But one of the things it shows is people must not think, including the agencies, including the executives at the time, right, and especially Congress, they must not think the agency has this power organically if we are trying to pass a statute to give them that power, right? And yes, maybe we're trying to find out what the Congress of 1970 thought, okay? But if the Congresses of 2009 through 2013 don't seem to think that the agency has this power and they need to pass new legislation to do it, right? I think that raises real questions then, which it's rational for courts to consider, and here I think Chief Justice Roberts and the majority did, that, that power is not there.
Especially when an agency is acting on the heels of a congressional effort that didn't succeed. It seems to me that it's particularly
this
suspicious.
month there's a new ATF regulation on serial numbers for weapons, the definition of receiver rule. And in that rule, Congress attempted to pass and failed to pass a tracing law. And the ATF implemented in this rule what Congress failed to pass through the democratic process.
Can I tell you what my favorite factor that wasn't in there but should be, would be, is that there should be a factor in this analysis that says, how closely does the implementing regulation resemble the statutory provision that it's implementing? Okay, because I remember clerking and in the late 90s, early aughts, right? Like you used to go to regulations, and the regulations looked pretty much like the statute, except there was a couple extra details and things like that, right? And before agencies really got deep into this idea of reverse engineering Chevron and creating whole new programs. So whereas the Clean Power Plan, right? You literally had the word best system, system in the statute. And to implement that, you had pages and pages and pages of regulatory text and program just pulled out of whole cloth, right? I mean, so I'm sad that somehow didn't get before the Supreme Court at that point, and that's not in the test yet, but that ought to be there.
That's an interesting point. Kara?
In thinking about the factor where it's, has this particular law been used this way, what sort of relationship do we see that relative to, say, dormant powers? I'm thinking of the CFPB back in the spring said, oh, hey, we found this power that we haven't been using, and now we're going to use it all the time to do bank examinations. And to me, I see a power that an agency has decided not to exercise over a period of time, cut similar but slightly different from a power that has existed and only been used in one way. And I have concerns that post-West Virginia, you're going to see legions of government attorneys going back to the statutes and saying, where can we hang our hat? Is that a fair concern to have?
Well, it's a fair concern to have because that's what they did with Chevron, right? But I think part of what West Virginia is intended to do is to try to prevent that, cut back on that.
So one of our online viewers, Teresa, has a question that's it's sort of an omnibus question. She says, how can we return our separation of powers that divides power between the executive, the judiciary, and the legislative Is West Virginia EPA just the first step in a kind of reclamation of that? Is that too big of a project? And how do we do it? So there's your question. It's kind of a big one.
Well, obviously, it is just one step in a much larger effort. The major questions doctrine does provide one roadblock to the administrative state in its assertion of power, but there are all sorts of problems of, in some instances, courts asserting too much power, Congress asserting too much power, and we need to deal with all of those things, which luckily we have a group like NCLA around that addresses many of the problems. We've talked about the non-delegation doctrine, about Chevron. There are about 8 different types of deference that we deal with at one time or another, and it's could be a lengthy battle, but I think that it's a fight worth fighting.
I think we had a question right up front.
I wondered if we might feel much more comfortable with delegation if there was a formal process for regulations pending to be reviewed by a rather enhanced congressional staff, that we would actually maybe double or triple congressional staffs for the sole purpose of reviewing regulations before they're finalized. That this might be a way to return the balance of power.
I think, go ahead. Well, so I would say it depends. If you're just talking about, and I'll say this as a former congressional staffer, if you're just talking about having congressional staff look at it, I don't think that gets you very far, because that happens a lot now. There is sort of opportunities to look at regulations, certainly for interested members of Congress. When I was at the Consumer Product Safety Commission, for example, Henry Waxman's staff was very interested in everything going on at the agency and was not bashful about suggesting directions of regulation. If you're talking about having Congress vote on a regulation after it's been promulgated, then now that I think gets you a lot of safety. I mean, I think maybe it gets you all the way there. And I'd love to see a system where agencies can cook things up and propose regulation, but it doesn't go into effect until Congress has voted it up or down. That I think would be helpful.
I do think that, and I made this point earlier, but I do think that Congress needs to play a bigger role, and that there possibly should be, and likely should be, larger congressional staffs with less delegation to the agencies in the first instance, but also more careful policing and of what comes out on the backside. I do think that is, as a practical matter, the route that libertarians, conservatives, theoretically would have the most opportunity to actually implement without, short of, some case ultimately kind of finding its way through the judiciary, right? But ultimately we're a democracy, right? And what's broken here is the delegations are broken, and that can be controlled if there's a will.
Especially if courts are willing to control it.
If they're, yes, but it comes back to accountability, as you said.
I don't think the real problem in Congress is a lack of staff. It's a fact that most members of Congress don't want to have to decide these questions. They would just as soon delegate to the agencies, so that if agencies get it wrong and they make unpopular decisions, Congress can say, well, that wasn't our fault, we didn't do it. And so the Congress has shown, say, through the Internal Revenue Code, that if it wants to write detailed statutes that are multi-volume, that set a lot of the rules, they can. But unfortunately, that's the exception rather than the rule.
Well, we're just about out of time, but I'll give each of you a chance for some final thoughts if you have them on today's question.
Well, I do think that there's a lot of good to be seen in the West Virginia versus EPA decision. I think that the court has shown the direction it is going in the future. I would like some of its decisions in the future to say something more specifically about Chevron for the reasons I've set forth before, but I think this has been an excellent first step.
Yeah, I would agree. I think this is a salutary step. I do think it is just a step, and it is not sufficient. I think that ultimately this will have the effect, I hope, of cutting back on some of the more aggressive rulemaking proposals and programs that some of the agencies are currently cooking up and pushing. But I don't think it is sufficient. And to get back to my kind of glass half full penumbra of this thing that I hope is that talking about the major questions doctrine and elevating the importance of those kinds of issues may ultimately result in judges and the lower courts taking a more careful eye to statutes at step one and looking more carefully at whether or not there really is an implied delegation of authority to agencies before applying Chevron. Because fundamentally, Chevron isn't about whether the statute's ambiguous, right? It's about whether there is ambiguity that the overall structure of the statute implies that the agency was expected to fill. And somehow, Chevron's application has been broken by many lower courts and simplified to a point where all we do is say, is it ambiguous? I'm going to throw my hands up without actually asking the question of, wait, is there an ambiguity and on a question, on a gap, that there is a technical expectation that the agency would fill, as opposed to, say, the Clean Power Plan, where they clearly weren't filling a gap, they were creating a whole new program.
Sometimes, as Judge O'Scanlan said, a statutory gap just is where Congress stopped legislating. And there's no,
That's it.
No power comes from that.
Yes.
Well, thank you to our guests. Thank you to the audience for your attentiveness and for your excellent questions. Please join me in thanking our guests.